Trump's new green card rule is here, and if you don't understand it before September 18th, 2026, your entire application could be at risk. If you're planning to sponsor a family member for the United States, the rules have changed. The public charge standard is becoming broader and more complex. In 2 months, this change will take effect, and it may make it harder for some immigrants to qualify for a green card. It may also affect people who have used public benefits, such as Medicaid, medical care, SNAP, public housing, and similar programs. If you or someone you know plans to file for a green card, this video explains what may happen over the next few months. All the updates, all the rules, who is affected, and who is exempt are covered here. Under the Immigration and Nationality Act, anyone applying for a green card must show that they are not likely to become a public charge on the U.S. government. That means a person should not be dependent on government assistance before becoming eligible for those benefits. If officers decide that someone is likely to rely on public resources before becoming eligible, the application can be denied, and a green card may not be approved. For decades, officers examined a person's overall situation, including age, health, ability to find work in the United States, and even past use of public benefits to decide whether the person qualified for a green card. Under the Biden administration in 2022, the rule was narrowed significantly. Only cash welfare programs and long-term institutional care were counted as public charge. So if someone received certain financial support from the government or needed extended institutional medical care before becoming eligible, that could potentially matter under that version of the rule. Programs like Medicaid, SNAP, food stamps, and public housing were not counted as public charge. So if a person used those benefits before becoming eligible and before receiving a green card, that would not affect the future green card case. Now, just a few days ago, the government rescinded that 2022 rule and returned to a broader approach. Starting September 18th, 2026, immigration officers will have broader authority to review individuals on a case-by-case basis and weigh different factors. They may consider any means-tested public benefits to determine whether someone is likely to be a public charge. That means not just cash benefits under the old rule, but many other benefits may be reviewed under the totality of the circumstances. The process is now much broader and more complicated. As a result, more people may face difficult reviews because many applicants already use some benefits, or may use them while going through the immigration process. Some applicants may find it harder to explain why they still qualify for a green card under the broader standard. Remember, this rule is not in effect yet. It becomes effective on September 18th, 2026. There will also be a new adjustment of status form with additional questions to verify eligibility and determine whether the public charge rule may apply. So let's look at the main changes and what they may mean. First, officers can now consider a wider range of benefits that may create issues in public charge reviews. That includes Medicaid, SNAP, and food stamps, housing assistance, and other programs such as CHIP and similar benefits. People using these programs could face more scrutiny later in their green card cases. Second, officers will have even broader discretion to evaluate health, education, family size, work history, assets, credit history, and future earning potential. These are factors that have not been emphasized in recent years, but they may return as part of the eligibility review. Even U.S. citizen children in immigrant households can sometimes be part of the overall analysis when officers assess how benefits affect the family's finances and stability. If this is helping you understand what's coming, hit that subscribe button right now, because immigration rules are changing fast in 2026, and you don't want to miss the next update that could directly affect your case. Public charge bonds are also becoming stricter. One important point: using benefits does not automatically mean denial in every case. It means officers now have more tools and more authority to review a case and decide whether a person could become a public charge. The use of benefits alone is not an automatic denial. The Department of Homeland Security estimates that more than 600,000 people could face these reviews each year. Many families are worried that, once the rule takes effect, they may drop benefits too quickly, which could affect health, children, and overall stability. Before making any decision like that, it is important to speak with an immigration attorney and understand how and whether it may affect the immigration case. There are still classes of immigrants who are exempt from this rule. Refugees are exempt. Asylum applicants are exempt. People with VAWA benefits are exempt. U visa beneficiaries are exempt. Other humanitarian categories such as SIJS and T visas are also exempt from the public charge rule. However, many family-based immigration cases and some employment-based cases can still be affected. A careful analysis of each situation is essential, and it is important to speak with an immigration attorney to determine whether and how the rule may apply. Here is an example. Maria is applying for a green card through her U.S. citizen spouse. Her family has used Medicaid for the past 2 years for their 2 U.S.-born children, and they also receive SNAP to help buy groceries. After September 18th, when Maria goes through her green card case, officers may weigh her situation more heavily and use it as part of the overall balancing analysis. Even though the family's income is modest, the fact that they rely on government assistance, even for the U.S. citizen children, could be a negative factor for some officers. In Maria's case, it is important to show evidence of future self-sufficiency. Maybe her job will improve, maybe she will receive a raise, maybe she is finishing school, or maybe her husband will get a better job. The goal is to show that this situation is temporary and that the family is moving toward greater stability. That kind of evidence can help in future interviews after September 18th and may improve the overall presentation of the case. Another example is David and his wife. They are adjusting status to a green card and currently receive Section 8 housing assistance from the government. If they file after September 18th, the Section 8 assistance will be part of the full review of their green card application. If they file before September 18th, they remain under the old rules and do not have to worry about the new deadline. Timing is very important in these cases. So what should you do now? If you are ready, if you are thinking about applying for a green card, if your documents are ready, if you are married, or if you are planning to do this for other family members, filing before September 18th may be the safer path. After September 18th, there will be a new form, so make sure not to file with an outdated version. Otherwise, the application could be rejected and the filing fee could be lost. After September 18th, try to minimize new means-tested public benefits, but never stop necessary care for children or anyone who truly needs support. Before changing anything, speak to an attorney. Gather strong evidence such as letters, proof of future income, proof that circumstances are improving, assets, insurance, and a solid affidavit of support or sponsor documentation. This change is expected to generate legal challenges, but if it moves forward, the government says it is intended to promote self-reliance, self-sufficiency, and the protection of public resources. In practice, however, it creates uncertainty for many families, especially those with U.S. citizen children. The best approach is to stay informed, understand what is allowed, and avoid making sudden decisions that could harm your health or your family's health. If you are unsure, get reliable legal guidance before changing anything significant. That is the full overview of what public charge means, what is changing, who may be affected, and who may be exempt. If this video helped you understand what's coming, make sure you're subscribed with notifications on, because these rules are moving fast, and I'll keep breaking down every update before it's too late for your case.